have a massive legal and political showdown. Former Kaduna State Governor Nasiru El-Rufai is dragging the DSS to court, demanding a whopping 2 billion naira. He is alleging illegal phone tapping, abuse of power, and even physical distress while in custody. In the clip we are about to watch from the TVC's Journalists Hangout, Babajide and the Asogwo breaks down the high-stake drama. We are seeing a fascinating mix of constitutional challenges and public sympathy strategy. Grab your popcorn, let's watch the clip, and I'll be right back with my critical take and analysis. Then I would also like to get your own perspectives in the comment section. So sit back and take a watch.
Now let's begin the conversation. There's a saying that those who live by power must sometimes answer to it. Former Kaduna State Governor Nasiru El-Rufai, once one of Nigeria's most formidable wielders of state authority, now finds himself on the other side of that equation. El-Rufai has filed an application at the Federal High Court in Abuja seeking to quash a 3-count criminal charge brought against him by the Department of State Services DSS, which alleges that he unlawfully intercepted the telephone communications of the National Security Advisor Nuhu Ribadu. He is simultaneously demanding 2 billion naira in damages, describing the prosecution as a naked and unconstitutional abuse of the criminal justice process. The former governor has been held by the ICPC since February 18, when his case came up for arraignment before Justice Joyce Abdul Malik. On Wednesday, he could not be produced in court, as the DSS, which filed the charges, has no control over the ICPC, which holds him. The matter has been adjourned to April 23rd. Now, claims that El-Rufai suffered a nosebleed in detention have been flatly denied by the ICPC, which dismissed the allegation made by his media aide as simply not true. Okay, Biko, 2 billion naira against the against the DSS. Now, when you look at the former Kaduna State Governor's his argument and also his justification, how valid are these claims?
Well, we are not lawyers. We do not pretend to be lawyers. And I cannot say at this stage whether his argument is valid or not until the law has been tested. We always like it as journalists when the law is tested. We will know those who know the law and those who do not know the law. So there is still time for the courts to look at this matter and determine whether the DSS was right to file this case against Nasiru El-Rufai. Nasiru El-Rufai faulted the particulars of the charge, describing them as vague and ambiguous. He also said that the prosecution did not state the specific date, time, phone number, duration, method, or device allegedly used. Okay. So that is something for the courts to decide. There are many of us who believe that didn't happen. You know. Some people believe that he was just baiting, deliberately baiting the security agencies by the claims that he made, by the allegations that he made. Now, if, as many people believe, that phone tapping didn't happen, then the DSS has to prove that indeed he tapped the lines of the NSA. That is why you can see he is saying that they did not state the specific date, time, phone number, duration, method, or device that was used on the day that the wiretapping was done. That would suggest that he believes that they do not have evidence that he actually tapped the NSA's phone line. So perhaps those who said he was grandstanding, perhaps they are right. People like Professor Perogi have said that they are convinced that nothing like that happened. And I have a friend who has been saying, look, this fellow was just baiting them, you know. But a person being baited has every reason to respond.
Exactly.
So I don't know how the DSS will deal with that. There is for their lawyers to deal with the situation that they found themselves, if indeed, you know, that wiretapping happened.
Actually happened. Now, he also alleged, even though the ICPSC has denied it, he alleged that he suffered a nosebleed, you know, which the ICPC has denied. How do you respond to this, first of all?
Was he the one who said he suffered a nosebleed, or some other people?
It's the media aide that said he has suffered nosebleeding. And the ICPC is now coming out to say, no, it didn't happen. This might be part of the baiting too. You know,
Part of the baiting?
Yes. You know,
While in custody?
Trying to whip up sentiments while he's in custody. You know, because this is what he needs. He needs people outside to know that he's undergoing persecution, not prosecution. You understand? And he has to try to look for, you know, events and things so that people will begin to see the government as, you know, prosecuting
bad
him.
light.
You know, so at this point, just like the ICPC said, I know our security agencies, the DSS, the EFCC, and I know they have one of the best health facilities in Nigeria.
Okay.
In fact, BKO that have gone to EFCC will tell you that if you go there, most of the people that are always going there, they feel as if they are home. You know,
It's a very beautiful place.
Very beautiful place.
You understand? So
And everywhere is clean.
Everywhere is clean. You know, so I'm not sure they have a clean facility like that, and somebody will be saying his nose is bleeding and all that. So, but the ICPC have, you know, denied it. If he gets to court at some point, if he wants to, you know, file charges against them on that, there will be health experts that will also you know, go through him to investigate to know whether truly he actually bled from his nose. You know, but what we just want to see is how this case can be done with, you know. Now that he has filed charges against the government, the DSS, the Nigerians will want to see how this will pan out. Because me too, I want to see if truly he actually tapped
the phone.
You know, the NSC's phone. And if he did that, you know, the DSS will have to prove it.
Yes.
You know, and that is what Nigerians
Then the other point that is making is that the DSS does not have the competence to institute the charge, and that the National Security Agencies Act recognizes the State Security Service
and not the DSS.
And not the DSS. And he's also arguing that the Act does not vest prosecutorial powers.
So he's saying that the DSS does not have prosecutorial powers?
Yes. That's the point that he's making. So, as I've said, their lawyers will respond.
Exactly. Let the lawyers deal with it.
It's a season film.
But this one, we have to finish it.
Yes.
We have to finish it.
A season film.
All right, gentlemen, straight to our next conversation. Every institution reaches a moment of reckoning when its failures grow too loud to ignore, and its future depends on the quality of the person.
There's an absolute tone to unpack from that conversation. What we just watched is a masterclass in how political and legal battles are fought on two fronts in Nigeria, inside the courtroom and in the court of public opinion. So let's really look at how Babajide, Tukolade, Otitoju'S and Asokwo James framed this entire saga, because they took very different yet equal important approaches to analyzing El-Rufai'S lawsuit against the Department of State Service, DSS. Babajide takes a highly analytical, legal-focused approach. He frames El-Rufai'S lawsuit as a necessary stress test for the Nigerian judicial system and the constitution. Notice the specific argument Babajide highlights. He points out that El-Rufai is attacking the very competence of the DSS to prosecute him, arguing that the National Security Agencies Act vests prosecutorial powers differently, Babajide used a lot of legal adjacent buzzwords, terms like competence and grandstanding, by pointing out that El-Rufai is demanding specific details from the DSS, the exact date, time, phone number, and device used for the alleged wiretapping of his calls with the NSA. Babajide is highlighting a classic legal defense strategy. He is essentially saying that if the state is going to accuse a citizen, they must bring receipts. If the DSS cannot produce this evidence, Babajide frames their actions as mere grandstanding, triggering skepticism about the government's true motive. On the other hand, Asoko James frames the situation completely differently. He steps away from the legal paperwork and looks at the psychological and public relations warfare at play. Asoko focuses heavily on El-Rufai's claim of suffering a nosebleed while in detention, which the ICPC flatly denied. Asoko frames these specific allegations as a calculated PR stunt. Listen to the emotional trigger and buzzword Asoko uses. He calls it baiting, an attempt to whip up sentiment, and an effort to paint the security agencies in a bad light. To counter El-Rufai's narrative of victimization, Asoko uses his own framing by praising the medical facilities of the DSS and the EFCC, claiming they are like being at home. When you compare the two, you see Babajide using triggers that appeal to our sense of justice and constitutional order, making us worry about state overreach and the naked and the unconstitutional abuse of power. Asoko conversely triggers our cynicism. He taps into the historical memories of Nigerians who are used to politicians suddenly falling ill or claiming abuse the moment they face accountability. Together, these two journalists provide a perfect snapshot of the dual nature of this case. This is simultaneously a rigorous legal dispute over boundaries of the state security power and a theoretical performance designed to win the sympathy of the Nigerian public. Now, let us move beyond the news desk and really look at the broader implication of this 2 billion naira lawsuit. My critical take on this issue is that this clash between Nasiru El-Rufai and the DSS is much bigger than individuals involved. It is a critical intersection of human rights, institutional overreach, and political maneuvering in Nigeria. First, we have to look at the severe allegations of the wiretapping. El-Rufai is claiming that his communications with the National Security Advisor were unlawfully intercepted. If this is true, it represents a terrifying breach of privacy and a cross overreach by the state security apparatus. It raises the fundamental questions: if a former state governor and a powerful political figure can have a private communication with the nation's top security advisor illegally intercepted, what does that mean for the average Nigerian citizen? The Constitution guarantees the right to privacy, and the court must take this opportunity to draw a very hard line regarding under what circumstances and with what warrants security agencies can tap phone lines. However, if El-Rufai is making this up to muddy the waters of his prosecution, it is equally dangerous, as it undermines public trust in the institution's tasked with keeping the country safe. Furthermore, this lawsuit highlights the often confusing and the overlapping jurisdiction of our security and anti-graft agencies. We are looking at a situation where a man is held by the ICPC, yet charges are seemingly being pushed or influenced by the DSS, prompting debates over who actually has the statutory power to prosecute. This lack of clear institutional boundaries creates loopholes that high-profile defendants can exploit. It turns what should be a straightforward pursuit of justice into a jurisdictional turf war. The judiciary has a massive responsibility here. As Babajide noted, the law needs to be tested. The court must use this 2 billion naira lawsuit not just to rule on El-Rufai's specific grievances, but to set a definite precedent that clearly outline the prosecutorial boundaries of the DSS versus the ICPC or EFCC. Finally, we cannot ignore the theoretical element of Nigerian political prosecution. The claim of nosebleed in custody fits perfectly into a long-standing trope in our political landscape, where VIP detainees suddenly develop mysterious ailments, arrive at court in wheelchairs, or claim physical mistreatment to stall trials and win public sympathy. This strategy is deliberately employed to shift the narrative from the actual allegation of misconduct to the narrative of political persecution and state-sponsored bullying. whether the nosebleed happened or not almost becoming secondary to the fact that it is being used as a weapon in a PRO war. It forces the security agencies onto the defensive, making them prove they aren't abusers rather than focusing on proving their case. Ultimately, this saga is a mirror reflecting the current state of our democracy. We need a system where security agencies operate strictly within the confines of the law without resorting to vague charges or alleged illegal surveillance. At the same time, we need a legal system robust enough to cut through the PRO stunts and political theatrics of the elite. The outcome of this case will send a very strong message about whether the rule of law applies equally to all, or if the justice system is just another battleground for the powerful to settle their scores. And that is my take on it. Guys, but I want to hear from you. What do you think about El-Rufai'S 2 billion naira lawsuit? Do you think the DSS overstepped their bound with the alleged wiretapping, or do you agree with Asukwo that this is all just a PR stunt to whip up public sentiment or sympathy rather? Drop your thoughts in the comment section below. Let's get the conversation going. If you enjoyed this breakdown, please do me a favor, hit that like button, share this video with your friends, and make sure you subscribe to Oba's Trending Gist and turn on the notification bell so you never miss out on the hottest political analysis. Thank you for watching, and I'll see you in the next video.